Welcome everybody to our weekly Wednesday webinar with the Property Law Alliance. It's so good to be back. We've had a productive week and now we're ready to tackle some very interesting and sexy questions that we have posed to us this week. It's always a pleasure to have Silna with us. Silna, welcome.
How are you doing? Chris. I'm so good, thank you. I must say, after it was super eventful between last week and this week, and now you're going to get used to me talking about the weather every single Wednesday. But what was up with that cyclone that hit us this weekend? I thought we were going to miss it. And no, when was it so windy? Monday morning. I woke up like at 2 and I'm like, okay, we're not going to have windows left after this. It's Dunskies. Like, it's been fantastic. But so my answer is I'm very good, thank you. It's not too cold. It was a little overly windy and rainy, but it seems like the rest of the week is going to be nice and cool. So from my side, I'm happy about the weather and therefore in a very good mood. Thank you.
Nice. Thank you, Silna, for introducing yourself and for also introducing Eloise. Because Eloise is the name of that cyclone.
And she is a windy lady.
Yes. No, lovely, Silna. Bruno, how are you doing, man?
No, I'm good. I actually happen to love weather like this, so I'm hoping it actually sticks around for a few more days. Save for the flooding, obviously that wasn't too pleasant. Yes. But yeah, nice overcast, rainy. It's good.
It's good weather just to take a blanket and sit around and draft some legal documents.
Let's not get overly excited now, Chris. I mean, let's not draft documents. I must say this is why I'm happy we're back in level 3, because I do enjoy, I won't even lie, I do enjoy working from home when the weather is like this, because you can, put up a curry to cook all day, and you can, wear your slippers if you want to. I really enjoy working from home in unfortunate weather.
No, exactly. And I think what's even more joyful is that you don't have to sit in traffic, and you know what happens as soon as one drop of rain, and there goes the traffic.
And IQs. People's IQs drop by 25 points. First raindrop, and people are like, done.
Oh gosh. No, lovely guys. Well, enough about the weather. Let's get underway quickly. We have a very interesting question to start this webinar off with. The question is posed around homeowners associations and with regards to the rules that exist within a homeowners association. So I'm going to pose the question to you guys quickly. It's around the installation, or rather conduct, that a homeowner can undertake while obviously owning a home and residing in an estate. The question is around the installation of a solar panel which went against the rules of that particular homeowners association. The homeowners association was approached for a request by the homeowner asking whether they could install this particular installation. The homeowners association then responded in writing stating that this was not going to be allowed and declined that request. A few weeks later, the homeowner then gets a good deal on this particular installation or unit and installs it nevertheless. Just, I don't really care what the homeowners association has to say. I'm going to install this and I'm going to make it aesthetically pleasing, and I'm going to fork out a great sum of money because these solar panels are quite expensive, and does it. The homeowners association gets wind of it either through a complaint or through their rounds that they're doing on the estate, and immediately send a letter out to the homeowner stating, please immediately remove this installation. We've declined you. It goes against what our rules are for this particular estate. Remove it immediately. Now, the question is, it's 2 parts. The first question is, what rights and recourse does that homeowners association have with regard to getting the homeowner to remove this particular installation? And then the second question is around, what rights or recourse does the homeowner have with regards to their rights in terms of whether this ruling by the homeowners association was it unfair? Was it unreasonable? And what rights do they have around that? So I think let's start with the first question. And Solna, I'm going to pose it toward you. What rights does the Homeowners Association have in this regard?
See, now we're going to have an unavoidable debate here. So Solna, your client's the homeowners, homeowner association.
Did you see how excited I got? I'm like, this is it. And I'm so happy you chose who's client, because if you asked me to pick either the Homeowners Association or the homeowner, I wouldn't have been able to choose one, because the argument is exciting on both sides. So Bruno, if we get bored on our arguments, we can switch lines if you like, and we can argue the opposite.
Like midway through the argument.
My sister, older sister, and I do that. We both weirdly argumentative, but we can argue properly without getting into a fight. And we actually do that quite often. We will fall into an argument and we'll argue about whatever, something silly that nobody ever talks about, like COVID vaccines or something like that. We will argue the point from one side, and then halfway we just swap and we switch argument, and then our other two sisters just stare at us like, what is wrong with you ladies? Okay, so I get the Homeowners Association. I'm actually quite happy about that, because my client's going to win this argument. Not because
confident, I see. Yes.
Thank you, Yoda. Yes. Confident indeed. So from the Homeowners Association, remember, our rights and our laws around community living and sectional title living, Homeowners Association, these kinds of shared community schemes is actually relatively new. It's not a very old part of our law. It's established, but not very well established. It's all the way. So we've always seen, even from Dutch law, in Dutch law we have a shared sort of ownership of a property. So it was further defined in South African law only in the early 70s, 1971. The Sectional Titles Act was published and then promulgated in 1973, which is not that long ago. Especially on legislation, it's relatively young. So we've only had sectional title schemes in that true sense of what we are currently seeing since the early 70s. And then now later with the Sectional Title Schemes Management Act and the Sectional Title Schemes Armed Services Act, which was promulgated, Bruno, correct me if I'm wrong, but it was 2014, 2015, if I recall correctly, which is brand new. I mean, that is newer than the CPA, which is not even that new anymore. But I mean, it's young, fresh, new legislation. So why I'm taking it all the way from the Dutch kids now is the reason why this is relevant is if we understand these kind of shared occupation, shared ownership, shared duties in our law, it will answer the question actually automatically, because the truth is, if you choose to form part of a homeowners association or a body corporate for that matter, you do agree to give away some of your own rights. You only have full right and full control and no interference in your right of ownership when you have a full title unit and somewhere in the Bundus where a municipality doesn't know about you. So this is not going to happen. Even in a full title unit, you do have limited rights, but the more rights that you are giving away, obviously, the less rights you retain. That's not really rocket science. So for instance, in a body corporate, you have conduct rules and and management rules, and that is what regulates the body corporate. And in a homeowners association, you don't have management rules, you don't have you have conduct rules, but you have a memorandum of incorporation, which is different from management rules in terms of the Sectional Title Schemes Management Act, but it's very similar in its nature, which is why in terms of the Community Schemes Ombud Services Act, you do have the ombud controlling homeowners associations, body corporates, all of those things. And homeowners associations are actually very, very similar in nature to a body corporate. So why I'm taking this whole wrong direction is, as much as you buy a property outside a full title unit that doesn't form part of homeowners association, you can do with the property as you please. If you want to paint it blue, you are more than welcome. I'm going to judge you. I'm sorry. I'm not even going to lie. I will judge, but you're welcome to do it. It's going to be weird. You can even hang like blue memorabilia like by your front door. You can do what you need. I mean a jersey, guys. Anyway, my point is you can do what you deem fit with the property. The moment you choose to buy in a homeowners association, you agree to the terms of the Memorandum of Incorporation. Your MOI can change. Any MOI, any management rules must be able to change, because it's not something that's static. It has to change and develop with the community scheme. So if the Memorandum of Incorporation says that you cannot have solar panels on your roof, you cannot have solar panels on your roof because you've decided and you chose to give some of your rights away. You still have your full right of ownership, but it's now a limited real right, because the limitations that you've agreed to, you did at the time of agreeing to buy into this homeowners association. So the homeowners association's rights are now going to sit in their conduct rules and their MOI. If their conduct rules were properly accepted in terms of the legislation that's relevant to this, in terms of the MOI, if they followed the correct procedure and they said all the parties agree, all the owners agree that nobody is allowed to have solar panels on their roofs or wherever else, that's the way it is. For instance, in the sectional title scheme where I live, everybody has these weird, silly green little thingies outside the front doors. Honestly, I don't like it. I think it's pretty ugly, but that is part of the deal when I bought into this particular scheme. If you then have an issue with that, you then call Bruno because he's going to now clearly argue for the owner. But the rights that the Homeowners Association has, it's much stronger, simply because all the owners agreed that this is what the aesthetics of the Homeowners Association would be. And I agree when buying into the scheme that I will adhere to these particular rules. Bruno, hit me. Let me see what you got from your research there while I was talking.
Hilda, if this was a boxing match, that was a pretty great first round. Let me just say this.
Thank you. I actually have my mitts right behind me, Bruno. I think yours are close.
Yeah, they're right there.
Exactly. We will, I'm just interrupting, Chris, we'll do that for a year-end thing this year. Bruno and I will both get our boxing gloves out because we both actually box, and we will, instead of having a normal Wednesday webinar, we'll have a bit of a boxing match. How about that?
That sounds good, actually.
As long as it doesn't involve
It'd be a nice
me getting
year-end
any
function.
punches.
You can be the ref.
No, exactly.
So as long as you can keep my hand up for a while afterwards, then you're good.
Okay, let's quickly hand over to Bruno. Bruno, your question obviously is with regards to the rights of the homeowner in this particular situation.
So, all right. So I suppose it basically, and I know this sounds a bit like over dramatic, but from a lot of experiences, it actually comes down to like a level of tyrannical rule. All right. Now, everything that Silna said is 100% true. That is, I mean, it even applies to our society as a whole, when we look at like the social contract, when we give up certain rights towards our government in order for them to be able to limit certain things, but protect us in the meantime. So we've give up our rights to freedom, but allow the police to, and give it up so that the police can actually control things like crime and, that sort of thing. So it's always been, it has always been a question of you choose what rights are important to you, and there's always a balance. But even with government, same applies to body corporate, same applies to HOAs. There comes a point sometimes where, and it's so true, the power actually gets to people's heads. You do sit sometimes with a board of trustees that make rules, but no one's actually 100% certain why the rules exist. We've even encountered rules that are biased towards certain governance, where you have certain owners or certain trustees that deal with things in certain ways. And they would rather lean the rules in their favor so that they've got the option to do it. So there's a couple of examples of this, but the reason why I'm bringing these up is the fact that even though it seems quite simple that everyone can contract and can decide, if you sign that piece of paper that says that you give up certain rights, you're done, it's dusted, you've given up those rights, and the trustees can make decisions on your behalf. But the one reason why this legislation was introduced is to allow a level of reasonableness to prevail. And what this means is that CSOS, which is the ombud that Silna was mentioning, they're actually empowered to look at certain rules and to determine whether these rules are fair, whether these rules are reasonable. And they're actually allowed to interfere with the provisions if they find that they're not. Funny enough, it deals a lot more with body corporates, because CSOS has quite a strict mandate when it comes to dealing with body corporate rules, even governing rules on an ongoing basis, which they don't necessarily have with HOAs. But the specific sections do actually allow people to lay complaints, even when it comes to HOA rules. So let's now bring it all into the scheme of things and the specific relevant facts. So obviously, what we're discussing now, it might be a real scenario, but we don't have all the facts at hand. But the question is, first of all, is there a rule? So that's the first thing that we need to ask. So was the installation of the solar panels done in contravention of the rule? Because if it's not in contravention of the rule, we need to ask ourselves, but hold on, then what gives the HOA the power to now change their mind and suddenly decide that they don't want the solar panels on, right? A lot of HOAs and body corporates have rules regarding aesthetics, so especially when it comes to construction, right? And they want things to look similar, they want things to look pretty. There's a specific reason why they'd have that, right? So the installation of these solar panels, how do they look like? Is there a rule that prohibits, and is there good reason for it, right? A good reason for that rule to exist. And again, this comes down to fairness and reasonableness. That's to say that if the body corporate or the HOA truly had good reason for these rules, and we go and contest it, and CSOS, for example, finds that, I'm sorry, but you know what, these are reasonable, in industry these are normal to have, then there shouldn't be a problem. But if for example, things like solar panels, again, it's a balance of rights, because one may find that solar panels aren't aesthetically displeasing, and in fact, they serve a very good purpose, from the perspective of having them there. So is it really fair? I mean, I'd understand exactly, as per Silna's example, painting the house blue has a very displeasing, a very negative effect on the houses around it. Solar panels, does it have the same effect? Is the rule really there to govern solar panels or to govern other displeasing things from happening? So is it a fair rule if it does exist? And that's also now the second determination is body corporates or HOAs cannot run their estate in tyranny, where they just make the decisions that they've got no good reason for decisions. And that's the underlying factor behind this type of legislation, is to make sure that things like that don't happen. And where I really draw this energy from isn't necessarily about solar panels, because I've never been experienced with that specific case, but we're struggling with this when it comes to Airbnbs, where the body corporates are just coming in and saying, well, you know what, we don't like short-term rentals, we're disallowing it. And we've had somewhere around 4 cases now where at the drop of a hat, they just decide they don't want to do it anymore. And that's that. And we've had to fight a couple of these now to try. They've also levied penalties, extra penalties on certain hosts. So instead of disallowing it or prohibiting it, they've increased penalties for certain offenses like parking and things like that. And the questions come up, is this fair, is this reasonable? What's CSOS jurisdiction in this whole thing? So obviously that's slightly more serious because you have to ask, but what's the reason of prohibiting it? Et cetera, et cetera. Solar panels, slightly different. I suppose we'd have to look at the specific instance, but same principle applies. Is it fair? If it's not fair, then sorry. And so from a recourse perspective, if the homeowner went forth, did something that wasn't necessarily against the conduct rules, he can go to CSOS and he can ask them to review this situation. If it wasn't against the rules, he's good. If it was against the rules, he can go ask for the rules to be reviewed. And once that happens, a decision can be made. And then we can have a conversation about whether the HOA can compel them to compel the owner to remove the solar panels or not.
Sure, that is a host of great information that both of you have given. I'm going to call this one a draw.
That's just copping out, man.
No, there's a reason. There's a very good reason that I'm calling it a draw, is because I know that both of you do boxing. I do not want to get punched for. I'm only playing. No, but thank you for that, guys. Thank you, Bruno. Thank you, Solna. I think we will quickly move on to the next question, which is with regards to the obtaining a digital lease agreement. Now, there's various platforms that one could obtain lease agreements from. These lease agreements would have a host of information in them. And if I were to download one as a layman and then try and make my own amendments to that particular lease agreement, there's obviously a risk involved in that, because I don't necessarily know what needs to be in there or what needs to be taken out of that lease agreement. So I just quickly wanted to ask Solna, you could take this question on, because Bruno just came out of a strong bout right there. What is your what is your view on whether I, as a layman, would be able to take a lease agreement and then edit it or amend it myself? What's the risks I could run into?
It's a very good question, and I'm so happy I get to answer this one. Since I've been the drafting attorney of the TPN leaseback now for a better part of 6 years. And I know how much energy I spend on this lease agreement, to the point where I refuse to draft a lease agreement for anybody else. I've moved most of the national rental agencies over to the TPN leaseback residential lease. Every single client that asks me to draft a lease, I always say, you're going to end up paying me thousands of rands, where you can get anyway a whole document back drafted by me for like $980 or something silly per year for unlimited use. It doesn't make sense for me to invest all that time and energy into one document just to, do some watered off version of it for someone else. But the point I'm trying to make is this particular lease agreement, well, it's 5 lease agreements and all the ancillary documents. I've spent almost 7 years developing this, and I change it still 2 to 3 times a year. Not me. In consultation, we're usually about 5, 6, 7 attorneys involved in decisions around this particular lease agreement. Now, the truth is, if we amend anything, I know exactly how it's going to relate to every other part of that particular lease agreement. And what makes me super sad is if I see somebody is using the TPN leaseback, I get excited because I know, okay, cool, they've catered for in all specific situations. But then the scary part is they amend things, and that creates ambiguity. If something's not in the particular lease agreement, it's because I don't think it's in the best interest of one of the parties involved. Or if something is in the agreement, it's because it comes from legislation or regulations or something else. it's there for a reason. And the problem is, if you start amending an agreement like that, you open the door for ambiguity or for a clause that is potentially illegal and unenforceable. So I prefer a lease agreement that might be longer than what a typical person wants, or that might not have the exact things they would like. But the reason why it's like that is there's years of thought and energy in those documentations. So I know I only refer to the TP and lease back, but it's because it's pretty close to my heart and I know exactly how it works. But it goes for anything else. If you pay an attorney to draft an agreement for you, or if you buy an agreement that was drafted by someone else, it's drafted in a specific way because a law contract is so complicated, law of interpretation and things like that, that most people have no idea. They don't know what kind of incidentalia, which is implied terms that's read into specific agreements. As if you are untrained in that particular field of law, not just untrained like you're a doctor and not a lawyer. I mean, if you are a criminal law attorney, you're not going to know the ins and outs of that particular contract, and it's not safe. Am I paranoid? Agree. Oh, you agree. Look at that.
We agree more often than not. So
I know.
Yeah. So but it's actually crazy. So what Silna's saying is so true. So just to give an example, first of all, lease agreements are completely, what's the best word to describe, like underplayed or underestimated, right? And I think we said this a couple of weeks ago, or in December, I can't remember when, but we basically said people will come to us to draft shareholders agreements and joint venture agreements and a whole range of complicated stuff. But then OTPs and lease agreements come in and people kind of just brush it off going, yeah, who cares? The reality is it's an agreement, it's binding. There's implications to it, but you're not treating it as serious as everything else. That's a problem for starters. So that's problem number one. A lease agreement is serious. So kind of understand why you're signing what you're signing. But then the worst part with leases and most other like consumer-based agreements is there's also pieces of legislation that go on and further cause these agreements to have to be very specifically drafted. So just to give an example, like something, for example, like a penalty clause in a lease agreement seems almost innocent. It's, you know what, why charge interest? Let me just charge like a administration penalty. And, you know, there we have it. It's a nice little penalty, just makes it easier, incentivizes the person to pay rent. Hell, in the eyes of the landlord, it might not even seem too unreasonable because it's not a high amount, but it's not allowed. So now you're going to put this in because you're like, you know, with these attorneys and their interest and like all the maths. I don't like maths. Here's 100 Rand, but it's not allowed. So there's a reason why we don't allow that to be in the agreement. And you put it in the agreement, you go and accrue these penalties, you disregard interest, and now there's a dispute. Guess what? You're not getting your penalties. Simple as that. And there's a whole range. That's just like the smallest thing I could think of now, but there's a whole range of stuff, cancellation periods, early cancellation penalties that you'd want to provide for so that you can actually charge it. That's for your own benefit as a landlord. It's very important. Sorry, my cat's going to come join us now.
Did it? Oh, how cute. Didn't my cat joined us sometime last year?
Yeah, no, she did. Except mine will stand here for a good period of time, stare at the screen, then probably try and get on my lap.
Bruno, does your cat have a lease agreement with you?
For my lap.
No. The cat has an employment contract with Bruno.
I'm the employee. Yeah.
Exactly.
So and like there's big things that actually protect the landlord as well, because it's typically landlords that go forth and try and amend or draft their own because they feel that they can get better rights against tenants, and sometimes they actually completely overshoot or undershoot, and they land up with less rights or unenforceable rights. So yeah, I mean, I suppose the thing is you pay us for a reason. And I've seen what happens when you decide not to go with us. So, you know, and like it's school fees. So it only happens once. I can promise you that.
Sure. Oh, thank you. Thank you for that, Bruno. I think we quickly just want to move on to the next question, which is also a very interesting question. The question was posed in the group, and it was a very loaded question, and you could see that it came from a place of deep emotional trauma that this particular individual was going through. To go into the question, or to summarize the question rather, it's around an issue of a property that was supposedly hijacked. Hijacked in the sense that this particular individual, their mother, had owned the property and it had then passed away. The stepfather, who's now involved, hijacks the property, or rather takes occupation of that property, and he passes away. In that process, well, of him passing away, he then passes that property on to his bloodline, to his kids and to his family. The question goes on to ask, is there a right here for the legal owner, and I'm assuming this is the legal owner being the daughter of the lady who initially owned the house, is there a legal right for her to evict these individuals who are in unlawful occupation of the property, as she claims? And what are the rights in terms of evictions that we are looking at in terms of this particular level of lockdown that we're in right now? I think let me pass this on to Silna now, because like we said, Bruno just had a good bout right there, to use fighting terms. And Silna, I don't know if you want to quickly take this one on.
Yes, I think first of all, my sincere condolences to the particular viewer. It's already a difficult thing to go through, and at the same time to then deal with family members and issues, it's the last thing that you need. So I'm really, really sorry for you. And the thing is, I hear that we're assuming that the daughter is the owner. I am curious about true ownership there. If the property is still in the process well, obviously the property was owned by the mother. Am I correct in my assumption there? Property was owned by the mother. My assumption is then that the property was bequeathed to the daughter, which is now our viewer in this. And if transfer already took place, then I'm quite happy. If transfer took place, you are the owner of the property. Easy peasy eviction, not even an issue. My concern is, I don't think you would have asked that question in the group if it was an easy peasy question. I think the problem is that this property is stuck in a deceased estate. And if there's one thing that Bruno and I share a deep sentiment about, except for boxing, it's evictions from deceased estates. It's a very big problem. And the reason why it's a problem is your ownership remains in dispute, and you retain this potential issue around ownership. So ownership will now, the party that has locus standi, so that has the right to bring an eviction application, is the executor of the estate. Now, if there's still an issue with the will, the appointment of the executor will already be an issue. So we're starting with a deceased estate eviction. Your problems basically start already way before you even talk about transfer of the property. So it's something, the easy answer is, if you're the owner of the property and these people are in the illegal occupation, easy eviction. Bring a court application, show that they are in illegal occupation, you're the owner of the property, bam, we have the eviction order. If I'm right in my assumption that there's an issue around the will, or if it's an interstate estate around the everything, then you unfortunately have to wait for either the executor of the estate to agree to bring the eviction application, or in my experience, I would rather recommend that you wait for transfer from the estate before you commence eviction proceedings, because the truth is these family members that are in occupation can still bring an application against the master of the High Court to undo the entire way that the estate's going to be dealt with. So I would then wait for unfortunately, transfer to take place before I commence eviction proceedings. Around whether we can do evictions right now or not, I'm actually going to leave that for Bruno as well, because I'm quite sure you're going to want to weigh in on the deceased estate still.
So insofar as the ceased estate, actually, I think you covered most of it. It's sometimes a disaster, especially because of the amount of time that that lapses before deceased estates actually wound up and resolved, depending if they're insolvent and whether the executor is actually doing the job that he's supposed to do. I mean, we've seen deceased estate gone for like a better part of a decade because the executor was appointed, they don't know what to do, and they've just never done anything. And ownership hasn't passed. And I mean, you find it a lot, especially where in lower income areas where property transfers aren't a thing. So people just move into properties and start living there. 20 years later, it turns out that somebody passed away and they just never took transfer. So things like that do happen, but I totally support Silna's view. The reality is easy eviction if transfers taken place. If not, maybe your focus should be on wrapping up this estate. And getting something done from that point and executing it from there, definitely. Insofar as the court process goes and where we are at the moment, Silna and I did actually have a discussion about this just before we started off, and I think we share the same sentiments. I think one of the worries that you had mentioned actually was people's reaction again to the regulations that have come out. It's as every time the regulations come out, people read it without context of the previous regulations, and a new panic ensues. And we didn't actually realize that this was the case because we just carried on with our lives going, oh, look, it hasn't changed, so we're all right. But obviously everyone else does. So again, we're sitting with situations where the sheriffs are now apprehensive again because of the regulations regarding evictions. So insofar, and I suppose there's different avenues or problems to discuss. So for example, there's the sheriff's apprehensions, and then what I've been experiencing, which I don't particularly like again, is the court's lack of dates and actually not being able to get things on the roll. But that's something I've always kind of had a gripe with, you know.
So from your now.
Yeah, no, it's terrible. And now there's, yeah, and I mean, last year we said there was a directive going, all those attorneys sending people to court don't. And that was pretty much us sending people to court. And now, unfortunately, we're kind of knocking again, going, well, you know what? It's at least give us a response then. Say, hi, I've received it, but we don't have a date for you. Give us something to go off. So tell me, Silna, your experience with the sheriffs, what have you, how many have said no to you? Let's ask it like that.
That's the funniest question. No, I've had a few no's, but luckily we've been able to work around it. We've had a very big issue with one of the sheriffs in Centurion, for instance, but you have to just go there with the entire regulation 37 and say, I understand that it starts off by saying no person may be evicted, but it's exactly the same as section 26 of the Constitution. It says no person may be evicted or have their property demolished without a court order. This is nothing new. This is all the way from promulgation of the Constitution. And so it's something very weird for me. And the issue is the sheriffs aren't the only problem parties. If we can at least explain to them, you have a court order. Okay, if you don't execute this order, it says you, the sheriff, must execute this order on this day. If you don't, you're in contempt of court. And that tends to help a little motivate them. The problem that we are seeing is, for instance, getting warrants issued. We specifically had an issue in Pretoria Match where the clerk said they're not going to issue because the court order was granted in lockdown level 1, and it says we can execute during the state of disaster, but now we're in level 3 and the regulations is not specific on that. So we're like, okay, but if it's not specific on that, how can you then decide as the clerk of the court that you're not going to issue a warrant? Long story short, I ended up telling my messenger and the particular secretary that we're just going to spend the entire afternoon until the next the messenger goes to court the next time, praying for this warrant. And the truth is, I prayed that warrant out of court, and it wasn't because I did anything spectacular. I think we are there. And I think if we start talking about that's how we're getting our warrants, We are seeing levels of frustration with evictions that I haven't seen before. We're getting it done, but it's not easy, and it takes much longer. And I appreciate the frustration that our clients are experiencing, because they call and they say, but I spoke to another attorney, they can get the warrants issued in 2 weeks. Okay, fabulous. I can also get it done in 2 weeks if the clerk is actually in court. And I mean, if you talk about 2 weeks to issue a warrant, which is something that's usually supposed to be done in court on the same day, it's stuff that's foreign to us as attorneys as well. And it does cause great frustration. But we're getting it done. Unfortunately, the issue with opposed motions not being heard, I don't want to go into it too much because I don't want to give an idea to anybody. But we are definitely stuck, especially on our opposed motions.
Yeah, absolutely. So from my side, my particular issues, especially with court dates. So warrants, we've had quite a few delays. We have managed to get one or two, like a couple issued, if I'm not mistaken. So I haven't.
Did you pray?
Yes, I did.
Good. Only way you get it.
But the court dates for me are it is just painful. I mean, we've seen the Joburg clusters now just overnight removing matters from the roll. And I mean, we had this conversation about whether we can justify it as urgent and a whole range of things, which is causing issues, because in my mind, that's actually only causing the court to get backlogged, because now they're going to need to consider things out. If they're going to spend that much time considering things, just hear the applications, especially on like some of the unopposed matters, which I don't understand why they can't just process quickly. And getting dates just in general, sometimes it's 2 weeks, sometimes we wait a month. And that's the thing, I suppose. It's so difficult to explain this to clients, because they go, cool, well, just manage my expectations. How long is it going to take? And you tell them it could take 1 day to 3 months. If people look at you and it's like, what kind of time frame is that? That makes no sense. 1 day to 3 months. It's like, well, I could get an answer tomorrow. I could get it in 3 months' time. We don't know. It depends who's sitting behind the computer on that day and whether you hit the jackpot. It is just getting to that point of frustration where, again, we're going to start trying to find creative ways of doing it. And again, we're going to get reprimanded, and it's going to go in the cycle. And I saw now there's new directives that have been proposed for the high courts, and nothing really speaks of the solution to the problem. They do about 10 pages of trials, and basically nothing on motions, except use case lines, which we've seen isn't like optimal. So yeah, anyway.
And it actually boggles my mind, to be honest. I get in match court.
Sure, it really does sound like a frustrating process.
I think I was off there for a second. It really is. So I think one of the things that really is quite amazing is we have case lines and we have online motions. I understand why the match court can sometimes say, okay, we're not hearing any opposed motions in lockdown level 3. I can sort of see that. But the High Court, I mean, whether a judge hears opposed or unopposed, it's over Teams anyway. So it does boggle my mind a little, but I'm very glad to hear that we're at least experiencing the same problem, because then at least we're going to experience the same solution at some stage.
Yeah, hopefully.
Sure. No, thank you, Bruno. Thank you, Silna. It's always amazing, even though I'm hosting this, to be part of it and to listen to the conversations you guys have. It's so informative, and it's also so entertaining as well. So thank you both for bringing yourselves to these webinars and for, informing us and keeping us up to date with exactly what's happening with the law right now. And although it's frustrating, as we can see from both your sides, you guys are really doing the most for your clients and doing the most in terms of donating your time and giving your time to these webinars as well. So I'd like to encourage and implore the viewers, and for those of you who watch this after the live video, to please post your questions and to please pose these questions to us, because as you can see, we really go in depth, and both Bruno and Solna do in terms of answering the questions and in terms of giving you context and background as to the legal standpoint that you have and your rights and recourse. I just wanted to thank you, Solna, and thank you, Bruno. Thank you so much for the time that we had for this Wednesday webinar. And yeah, this is a really, really amazing time that we've had. And thank you so much. And goodbye to the viewers for this particular episode. And we'll see you next week. Please do join us. And yeah, cheers, Solna. Cheers, Bruno.
Thank you. Cheers, everyone.
Cheers. Thanks so much. Bye.
Bye-bye.